Yeah, that's it, Chair. And the DG as well, he will join us and leave us because there is a meeting that he has to attend in the NCOP. Thank you, Chair.
Okay. Mam Kakaza?
I'm covered. Thank you, Chair.
You are covered.
Yes.
Thank you. Any other further apologies, honorable members?
Yes, Chair. Chairperson. Yes, I've sent an SMS notifying the chairperson that I'll be leaving at 10 for a mini plenary. And again, I might be off, chairperson, simply because we are without electricity here since yesterday afternoon. So my gadget batteries are very low.
Noted, Ndabezit.
Thank you.
Any further apologies, honorable members? If none, let us welcome you, honorable members, on our portfolio committee meeting. As we once again continue in doing our work in ensuring that we further the mandate bestowed upon us by Parliament on the department or the Portfolio Committee on Agriculture, Land Reform and Rural Development. I'll take this opportunity, therefore, to welcome the Minister, Umamuti Diza. Molweni, Minister. Ujani, Minister.
Ngikhona sihlalo ngisendleleni ngizalokhu ndiqhawuka nje mhlawumbe kodwa ndithe mandingene noma ndixolisile okuba nje ningalwi nam.
Hayi ke kuyavakala siyabulela. Let us also welcome the officials of the department as led by the DG, Ndate Ramasodi. And welcome honorable members, all our respected guests and the media that is been able to join the portfolio committee session. Ours today, honorable members, is to engage with the response. Says that we will be having from the Department of Agriculture, Land Reform and Rural Development. On the public hearings, we had submissions were made, both in public inputs, which were written and oral submissions on the Agricultural Produce Agents Amendment Bill. We will therefore invite the Honorable Minister and the department to take us through their responses on the bill. Thank you. I'll now hand over to the Honorable Minister and the department.
Thank you very much, Chairperson of the Portfolio Committee and members. I would request that I close my video in order to improve my network as I'm on the road. We would like to appreciate the presentation that have been made by a number of stakeholders on this bill, which we know has really been in the making for a long time. We have endeavored to answer to the issues that have been raised, and I trust that that will enable the committee to finally finalize its deliberations and advise on the way forward in this regard. I will therefore like to ask Chairperson, without wasting time, that the DG leads the team of the department in making the responses to you. Thank you very much.
Thank you, Honorable Minister Mamuti Diza. Ndate Ramasodi, the DG of the Department of Agricultural and Reform and Rural Development, you may proceed.
Thank you very much, Honorable Chair. The engagements that we are going to have today is an offshoot of the engagements that previously this portfolio committee had with the stakeholders, where some of the stakeholders belatedly had new comments that came into the bill. Some of those were comments that were there initially when the bill started. Today, we will take through the portfolio committee a series of comments that we have received from the stakeholders, most of them from an exporter's point of view, where we will delineate what the comments were. We will also summarize whether these are recommended to be accepted or not to be accepted. There are those that came in a little bit late for the department in terms of consideration for two issues, Honorable Chair, that there's probity that's needed when there is a new comment that is on the table from a legal point of view and also from a socio-economic point of view, that we will also request guidance from the portfolio committee, as some of those are substantive and are nuanced. Today, we will be taken through this presentation by my colleague, Mr. Gelembe, who's the director within the unit that is responsible for APAC. And with me on the platform, I've got Mayor Kwenakomape with her team from Economic Development, Trade and Marketing, who will be responding to the questions that the August Portfolio Committee would have. Thank you very much, Chair. If we may permit Ndate Gelembe to make the presentation.
With your indulgence, Chair, I apologize for coming through. Can I be allowed to share the screen from my side, Chair?
And the Secretariat assist in enabling the department to be co-host.
The name of the person, Chair?
It is Kwenakomape.
Yes.
Okay. Permission granted, Chair.
It's indicating that host disabled participant screen sharing. Chair, well, I'm still waiting for the permission to share the presentation. I would like to greet you together with the honorable members and just indicate the approach that we have followed in order to present the 86 pages that we have shared with the members in terms of the responses to the responses that we have received from the public hearings. What we thought I would do was to just give a context into the bill itself, where we started, how it came about, so that we are all in the same page. And as the DG indicated, we have just selected the key responses that we wanted to share with the committee. And after that, should the members require, have questions with regards to the big document that we have shared, we are we are ready to respond to the questions as posed. Chair, I still do not have the sharing rights. It says the host is disabled participant sharing, screen sharing.
From my side, Kweneke is a co-host, so she should be able to share the presentation.
Okay. I'll hand over to you and Tate Kelembe. Is it showing, Chair?
Yes, ma'am.
Yes, we can see the slides. If you can just make them bigger so we just see the one slide. Thank you. You may proceed.
And Tate Kelembe, are you in? Chair, I don't hear him responding. I will just indicate that the background of the outline of the presentation, we'll look into the background and we'll have the historical background into the bill itself. We'll have a summary of legal opinion and then go to the redrafting of the bill, amendments of specific and key sections, and then we'll look into the key responses to the key proposals. Chairperson, through you, and this slides on the background generally gives a perspective into the environment in which the farmers operate, the risks that they are involved with, they are facing as they do business. It's not only on their farm level. Even when the produce is supposed to leave their farm, they are still faced with those the risk. For example, we look at the price risks, the market risks, and in the market, there is theft that occurs to their products. And besides the theft, their products, at some point, you'd find that the quality deteriorates, just to mention just a few of those. And to the farmer's nightmare, the risk increases with when they deal with the agents. They will transfer the product through to the agent, and you find that product, even if it's no longer in their hand, they still carry the risk of the asset, if I want to call it that is not with them. And the agents, on the other hand, Chair, through you, they will get commission from the produce that they received if they are able to sell it on behalf of the farmer, and they barely. They don't even take a responsibility. I mean, share the risk with the farmer in terms of the loss of the product. But if they are successful in selling that product, they are more than willing to share in the process of the sale. And now we have the Agricultural Produce Agents Act number 92. Act 1992, Act number 12 of 1992, as amended by Act 47 of 2003, which seeks to protect farmers by regulating the occupations of the fresh produce, export, and livestock agents. However, this Act, Chair, has got some defects within it. It's more effective in regulating the fresh produce agents at the expense, but actually, let me not say at the expense, but leaves out the regulation of livestock and export agents. Now, Chair, when it comes to how did this bill come about? Firstly, Chair, there was the National Agricultural Marketing Council through Section 7 was instructed by the then minister, to invoke Section 7 in order to investigate the state of the fresh produce marketing system in the country. And with the results of the investigation,
Recording in progress.
They made some.
Please proceed. We don't see the presentation on the screen. Ralph, can you assist your team? We seem to have no one presenting. Tate Ramasodi?
Okay, Chair, Mr. Kilemba is struggling to log in, but he's busy trying to. I've just uploaded the presentation.
Okay. Chair, I'm just also trying to determine what's happening from our side. Sorry about that. I was on the phone just trying to determine. I'll be into the session.
Yes, the presentation is back. If we can just enlarge it for us to better follow the presentation. Thank you. And then if we can get the presenter going.
Thank you. Honorable Chair, Auswena has been presenting to herself on the other side. In actual fact, I found her busy presenting. There might be a technical glitch that we have got to sort out. She will join back into the session. She will indicate when she is back. But I think where she was, in terms of the presentation, it's the indication of the Section 7 committee report. Now, Section 7 of the National Agricultural Marketing Council, which takes effect from the the Marketing of Agricultural Products Act, makes provision for the committee to set up investigations into any other issue that is within that particular act. And this time around, there was an investigation that was done on the fresh produce. And that investigation came up with a few issues that called for the engagements on the bill itself, on the act itself, and looking broadly and how we broaden it up to deal with livestock and also dealing with the exports, which are part and parcel of the value chain that deals with the sector per se. And now there were various issues that Section 7 touched on, and mainly on how the bill was. The proposals that were there, Honorable Chair, were of such a nature that the Office of the Chief State Law Advisor made a telling contribution that because the amendments were many, we just needed to then come up with a new bill and repeal the bill. Now, I would not focus on the issues around the constitutionality of the bill. Suffice to indicate that when we broadly brought it back, there were a few things that the Office of the Chief State Law Advisor were thinking that we were overextending the purpose of the bill, where we were actually trying to go beyond, we were going beyond the buying and selling of produce. And going deeper into the issues around management, ownership, and market infrastructure. And the Office of the Chief State Law Advisor were of the view that we need to broaden it as opposed to limiting it as it was previously. So that was the issue around the constitutionality that was at play at that time. The next slide. In terms of the next slide, I think there is a broader contextualization that when we look at the bill, we are replicating what is in the bill. And therefore, a new bill would have not been necessary at that stage. So I think what was also important was the balance that was brought to say what government proposed in terms of the bill is, and how we need to then amend to move forward. I think this background is the background that we had even provided before in terms of the engagement. And I think from here we can move forward to the proposals that were made in this bill. Can we go to the proposals, the recommendations that came through? Thank you very much. I think that's still the background. Please move to the recommendations that came in. I know that we have got limited time. Thank you. Thank you very much. Let me check, Chair, through you. If the colleagues are not in, I will take the portfolio committee through the engagements and the request that came through. Let me check whether Siskwena is in or Mr. Kelembe is in. If not, let me proceed. The first issue, let me just say, the way that the presentation would be, we first looked at what the in the broader document, there's an indication of how we have come up with this. We look at the definitions, and then we go sequentially in terms of the act, where the areas are and what the inputs were. Now, one of the contestations was around the first input that came in was around the definition of an exporter, where there was an issue to say, why would we not also include the grower exporters? Now, our understanding of a grower exporter is that they are actually responsible for their own product, and therefore they do not become agents. Otherwise, we will be accepting that they become agents of themselves, because a grower exporter would be producing and selling their own produce, and therefore they would be exempted from that provision to be called agents, according to the interpretation. The next question was whether these agents would be required to register as fresh produce agents, and therefore the answer is yes. The Act makes provision for that. Next one, and that is those are the reasons why we did not accept that. The comments from FPEF are also saying it is impractical and unreasonable to require all members and directors to acquire registration certificate. Now, there is a provision there that actually is amended to provide that the director of a company and a member of a CC and a trustee of a trust who acts as a fresh produce must also be registered as a fresh produce. This is intended just to make sure that if there is wrongful behavior, it can be pinned on a particular individual instead of then going to a company level. So because the Act is looking at an agent and their behavior, that is why the request is not accepted. The other issue that was there was around the acquisition of gain, and it really goes to the fact that that the earlier comment that we had on the grower exporter, where we are of the opinion that the grower exporter does not become an agent because it's their own product. Next slide. We have accepted the recommendation that came around insurance, that's around Fidelity insurance, credit insurance, and marine insurance. And that will be with the recommendation that comes, we will insert it into the bill. Next. Next slide. There was also an issue around producer trust accounts for export agents. And maybe what we need to be saying is that it is very important that whoever is exporting should be protected through a trust account. And it is our firm belief that through transparency, which is a key responsibility of the agents, one would need to have a clear line of how all the costs that are being involved are being calculated, and how the applicable rates are being applied, so that when we open up a trust account, it would be easy to monitor. The very same trust account is applicable and being used in the local market, and it has been proven to assist a great deal in assisting the fresh produce farmers at this moment. The next slide. From where we are sitting, Honorable Chair, we are of the opinion that there is a great deal of expectation that comes with the bill, and the bill, in terms of the previous engagements that we have had with the committee, has led to a lot of inputs that came from the fresh produce exporters. We have got many pages where we reflect on each and every input that came, because we gave it a clear line in terms of the engagements. We also have got reasons why we are not accepting or we are proposing that it should not be accepted. There are reasons where we are proposing for the acceptance, and there are reasons where we think that the inputs that were made by the exporters forum would need a little bit more probing other than what we are currently having. Where we are sitting, we are of a view that the current bill was dealing with the issues that were raised by Section 7 investigation. A Section 7 that is made provision for in the Marketing of Agricultural Produce Act. This Act of Parliament, which provides for a transparent and an open way of how fresh produce is being dealt with in the country amongst a few of the provincials that are there. And we think, we are of the opinion that what we are currently having would advance and almost give provisions where the interest of the exporters are also balanced against the vagaries that we are having in international trade. Thank you very much, Chair, and we have got to apologize as a department for the glitches that happened during this presentation, and we hope that it will be going better next time, Chairperson. Thank you.
Thank you, DG, Dr. Ramasodi. Is that all your presenters, DG? Any other input?
Chairperson, if Chairperson allows me to check in terms of the presenters who are here, I will. I don't think that let me just give over to Mr. Douglas Mosese, who has been working on the bill itself, just to give other silent features that are there. But we thought that we should just summarize the long presentation. We would have taken, I think, more than an hour into just highlighting what the essence of that bill would be. Thank you. And that is Douglas.
Yes, thank you. Thank you very much, Honorable Chair, DG Dr. Ramasodi, all members present here. Well, yeah, just to make a few additions and more emphasis on some of the points already made. The comments that we received on the bill, indeed it was quite a voluminous submissions by the industry, and we made sure that we go through each and every one of those comments and responded to them in a separate document. But as we studied the comments, most of them were of a tactical or technical nature, just saying replace means with this and so forth, those kinds of things. But our reading of this thing was that the major area that is affected by most of the comments that are there, and which will have substantial impact on the purpose of the bill itself, is the part that deals with the marine as well as fidelity insurance for export agents. And the second part, which is of critical importance to the bill, because it actually also affect the direction, the operation of the value chain, would be the requirement for trust accounts for export agents, And the third issue is the issue relating to every director having to register with APAC. So all these three issues I have mentioned, like I said, they are quite critical. Once we make any change on them, obviously, we are changing the direction that we actually need to take as a country. And let me start with the first one, the one on Fidelity as well as marine insurance. We had a lengthy discussion about it amongst ourselves as the department and also with APAC, who is the regulator of agents given the powers to do so by this very same legislation. And on discussion of that point, it was it agreed that, well, it was confirmed that indeed having that kind of an insurance will make us as a country to lose certain markets, especially the African markets as well as Russia, because those countries as submitted by agents last time do not accept the consignment to some of these regions. Therefore, enforcing this part then would make it difficult indeed for the export agents, and it will make it hard for them to export to the markets that I have already mentioned. So on that one, we concede that indeed we may have to relook at the bill and make sure we go back on it and relook at it. I think that is the recommendation from our side as well, as far as that is concerned. The second issue on the producer trust account by export agents. This one is extremely important, mainly because we know the impact it has made on the local market. The fresh produce agents currently, they are required to open a trust account, which account will be used for the monies belonging to producers, as and when agents sell on behalf of farmers. Whenever they receive payments, then they receive those payments in the trust account, and the trust account is separated from the business account of the agents themselves. So this makes it extremely easier for APAC to make investigations in the event where there is a complaint from the farmer, particularly relating to theft and things of that nature. And through this very same trust account, really APAC has made a huge success over the years in terms of prosecuting and the agents who would be a little bit more adventurous when it comes to handling the monies belonging to farmers. So it has been a huge success because lots of monies were recovered on behalf of the farmers by APAC, mainly because there was an account that they can easily look at, and this account is meant for farmers and the farmers only. So then it's easier for APAC to do its work, because just imagine a situation where now the monies go through the company account. So you have lots of legalities you have to go through in order for us as regulators to gain access to such accounts in the event of investigations. So in short, the one on trust accounts for export agents is very important, and we feel that it has to be at all costs part of this particular bill, because it's in the interest of the farmers. I think another point we considered on this one was that we read lots of inputs from the export agents mainly and other stakeholders who submitted. And on this part, we were looking for a comment that will help us maybe to do it differently, but we couldn't find any suggestion in the comments that gives us some ideas on how else can it be done. And as it is, the trust account is the only way to manage this issue. It's very important in the interest of the farmer. So the third point on the producer exporter there were comments that we have to amend, make some changes on the bill to allow for registration of what they call the export farmer, meaning that would be somebody who farms and also have a trading company that exports the produce on their behalf. So this one we found very, very difficult to accept, mainly because if the farmer trades for himself or for herself, they actually don't fall within the ambit of this legislation, mainly because this bill seeks to provide protection to farmers who sell their produce through a third party or the agents. And now, if in the case where the farmer himself,
excuse me, Stephanie Nell, can we not smoke in the house, please? Can we please not smoke on the house? We are bound by parliamentary rules, and we do not smoke in the National Assembly. So please don't refrain from doing so. Thank you. Please, DG, maybe at this juncture, I must plead with yourselves as to why we are having this session. And I think it is important to highlight that we're not just looking for responses to the background of this bill. It is a technical bill, and as a committee, we have an obligation to go through all the subsections, not to just pick and choose what we want to attend to. There were real substantial submissions made, written and orally, and we would like responses to what was submitted. Proceed.
Thank you very much. I was actually on the last point regarding the exporter producer. On that one, we indeed have a view that because the producer exporter exports their own produce, therefore there is no need to actually protect them from anyone. So I think that those are some of the considerations we actually looked at. Thank you very much, Chair, and thanks, DG.
I think with the guidance of the chair, Dr. Musese, if you can just take the honorable members through the comments in the larger document so that we can section by section guide what has been submitted and our comments, but not going through from definitions and then going through the other sections. Thank you.
Yeah, thank you very much, DG. Let me just. Can I then request that the document be shared, and also check if Ntate Mokoena is here to take us through the document. Mr. Mokoena, are you here?
Mr. Musese, good morning, Minister and honorable members of Parliament and the Chair. Yes, I'm here. I'm Mr. July Mokoena. I'm also part of the response team from the department. So the first comment there, if I might be allowed to take members of Parliament and everybody through the comments that we received. The first comment was in relation to the definition of an agent. And in this agent, we were requested to look at what is meant by the acquisition of gain. And it is the recommendation was that the word seller should also be deleted, since an agent's function is not to procure. And our response is that this recommendation is not accepted because an agent is someone, according to our understanding, who holds and sells agricultural produce on behalf of another. In this case, which we mean the farmer or the principal, as mentioned in the act and in the bill. The second one is also the same, and our response is also similar, because in this one it was in relation to what Mr. Moses have mentioned earlier, that the issue of a grower entity, and we're saying here that in this case the definition will stand that anybody who sells on behalf of another person will be an agent, but that who sell on his own will not be regarded as an export agent. The third one deals with the definition of local market. I think here the main message was whether we intend on regulating local retailers, of which we are saying that's not the intention of this bill. The intention of this bill is to regulate the occupation of agents in the market, in auctions in relation to livestock agents, and also in the export space where it talks to export agents. So here, if I might expand it without reading, the tone was that this bill was mainly intended for local market from its origin. So since 1992, this bill was intended for local export, local fresh produce agent. And our response is that the current act as it is now, it makes mention to export agent, it regulates export agent. So the issue of defining local market in the bill, we think that it's not going to be relevant, because the bill itself, the act as it is now, it makes that provision. If I might go down, Chair. This one deals with the definition of agent, fresh produce agent. Here we were requested to look at the let me just confirm. Yes, this one is similar to the one that I mentioned earlier, that we were requested to classify fresh produce agent as local fresh produce agent, because the fresh produce agent also trade fresh produce. So that the distinction was that we must distinguish municipal fresh produce market as local market, and have export agent. And we're saying that these terminologies are what these terminologies are currently used in the industry. So there is, according to our knowledge, it will be no need to change these terminologies, because everybody understands when we say fresh produce agent and export agent. We can move. The definition of local market, I've spoken about it earlier. We can pass. This one on Roman figure number 2, I think it deals with the, let me just confirm. So the third point there, Chair, this was very much came often. It dealt with the produce that failed to meet the standard for export, and export agents there were saying whether they need to register also in the local market as fresh produce agent. And we're saying that that will be a requirement for anybody who wants to trade in the fresh produce markets to also register as fresh produce agents, so that the rules and the act can be used on them, so that there is consistency in the application of law. On Roman figure number 4, I've spoken about this one. It's about the grower exporter, which we have highlighted that we are not intending to regulate somebody who trade on their own, but we want to regulate those that are trading on behalf of another farmer or another principal. If I might move to Roman figure number 5, I have dealt with this one in the first instances where the issue of acquisition of gain was in relation to those that are selling on their behalf, and we are saying that the risk of profit or loss in this case remain with that producing entity, and it's not the area that we want to regulate. We're specifically looking for those that are trading on behalf of farmers so that we can protect their interest as such. So we can move, Chair. Chair.
Which one? The PowerPoint? The PowerPoint was made by the DG, and all of those points, they skipped them. It came from Mugwena's side, July.
Mr. Msese. Chair, can I proceed?
I'm not sure at this stage, because unless if we will summarize after the presentation by Mugwena, because
Chair.
Sounds like you're speaking to the chair.
May I proceed, honorable members?
Yes, we've asked you to continue.
Okay, thanks. There was another voice. Thanks. The issue there on Roman figure number 1, the proposal was that this bill must also take into account the various transactions that the fresh produce is traded in the export market, such as consignment, fixed price, minimum guarantee price. And we're saying that we are not in a position to accept this recommendation because the bill's intention is to regulate the conduct of an agent to protect producers and not to prescribe various methods of transactions. That's our response there. The second one, it says that, let me just confirm. So this one, it was in relation to the trading of the double cost that will be incurred there. Our response is that we are not accepting this recommendation because we are of a belief that this does not talk to what we intend to do, which is to regulate somebody who handles the produce on behalf of another person. The second one, the Roman figure number 1 on the next page, it deals with the definition of export agent, and it was saying that it is critical that the extent of passing of risk or loss should be clarified, and our position is that the risk of profit or loss at all times remains with the principal, and that is very clear in the proposed bill in all what we're mentioning in the bill, it's very clear that we were mentioning that the risk of loss or profit at all times will remain with the farmer or the principal. Roman figure number 1. Let me just see. It's the same as the above, Chair, if you'll allow me for the sake of time to pass, because it deals with the issue of the risk of loss or profit. That Roman figure there deals with who qualifies as an agent, and it also deals with the third party, in which case here we're talking about the grower or the pack house, and it's similar to the one that I've spoken about, that we are saying that any grower who's trading on his or her own behalf is not going to be regarded as an agent. So it's similar to the one above, and I request that we pass, because we have responded to that Chair. The one below, which says that it talks about the proposal that we're making in the bill, so to talk to or to also regulate, extend regulation to members and directors of CCs and trusts of those agencies. The reason for that is that we want the disciplinary processes to not only talk to the agency itself, but on where the merit dictates, to also specifically deal with the individual responsible for that particular act. And according to our own understanding, this particular provision will also help the agency or the company, because where fault was on an individual, the company will be allowed to trade in the market floor, while APEC deals specifically with that specific director or trustee that will have broken the law in the market. So I can go to the one below that start with for purposes of consistency. Yeah, there. The request here was that we need to consolidate the definition of agent into one, but we want to make it clear that this bill regulates 3 categories of agent, which are export agent, livestock agent, and fresh produce agent, and we want that distinction to be very clear in the bill. The second one, Chair, that makes reference to hold himself or herself out. This recommendation we clearly accept, and we recommend that it be incorporated into the bill. We can move to the one below. The one below, Chair, which is the deletion of the word purchase, we clearly accept, and we can move to the one that's that. Yeah. Here, the request was that we need to use the word means. We need to use the word includes rather than the word means. And our recommendation is that the word means is commonly used in bills, and therefore this proposal will not make any material difference. I can move to the one below. This one, Chair, is similar to the one that I've spoken about, because this proposal is extended to also deal with individual directors of companies or members of close corporation, which I've dealt with above. Let me see this one. This one we have dealt with it because it's the same proposal to cluster the definition of agents to refer to export, livestock, and fresh produce agent, and we have said that we want to make it very clear that we want those three categories to come out very clear in the bill, and to really make it clear for the people to know who we're talking about in specific clauses in the okay. This one, I think the proposal was that we need to talk about employees of an agent, and we're saying that the current amendment provide clarity that the bill regulate all three categories, and reference to sections remain as in the bill, because we also make mention of regulating also the employees in that agency. If I might move to the one there, this one we gladly accept, Chair, and it will be incorporated into the bill. This one. Okay, this one is an extension of the request to cluster this definition. So it was saying that references and or to subsection and sections of the Act need to be excluded, because we will have incorporated that definition of an agent, which we have rejected above, and we made it clear that we want to those three categories to come out clear in the bill. So yeah, we have spoken about that one. The one below, Chair, it speaks about the schedule in the bill. We are saying there that the current Act, actually currently as it is now, provides for APEC to request the minister to amend the schedule and publish in the Government Gazette. So if we are to change the definition of agricultural product, or amend the schedule, it will really be a very big task to do, because this one, it can be done even now. It doesn't need a serious amendment. It can be done through changing of the schedule as provided for by the current Act in Section 2. So yeah, that we can pass this one. This one, the definition of an auditor, we are gladly accepting this proposal, and it will be incorporated into the bill. So is the second one, and the reference to business day, it will be included in the bill. The one on number F, the definition of consumer, it is proposed to amend the definition of consumer to include any person to whom agricultural products are marketed. Let me see. So according to our understanding, this word consumer, it can't be defined, Chair, because it appears only once in the bill, and therefore it doesn't warrant us to define it according to the style of legislative drafting. The one on the definition of a deputy register, Chair, we accept it, and it will be deleted there, because there are no any duties that are provided for in the current proposal. So we will gladly accept that proposal. So is the next one on the definition of trust account. We accept that recommendation. The one on the risk of profit or loss, Chair, I've spoken about it above, and I will request that we move in the interest of time. Okay, this one, Chair, is similar to the one members of Parliament and everybody. It relates to what we've spoken about, the proposal to also extend the definition of agents to also talk to directors and trustees of trusts and directors of close corporation. The proposal here was that we need to issue a certificate of good standing on an annual basis to those members. And our proposal, our view still stands that we will want to still have to give APEC powers to also discipline individual director or trustee in that particular agency if the merit of that case dictates so. And we are not accepting this recommendation, Chair, because based on our experiences, as Mr. Moses have mentioned, on the fresh produce agent category, which APEC has all the powers provided by the current Act, we have shown that some of the transgressions comes from individual members, which warrant that those members must be dealt so as such. And so we are not accepting this proposal as we've mentioned above. So I will request that we move to the next one. This one, Chair, is the same as the one above. It talks about the proposal to issue a certificate in good standing, so we can pass. So as the next one on page, on the one that the heading starts with page 5, we can move to the next one because it's the same as the one above. Yeah, can I see the full, that section 3, the section 3 can yeah. Okay, Chair, this one is also similar to the one above, because in the case of fresh produce agent, the fresh produce agent will be required to be registered with APEC, and they will be issued with a fertility fund certificate. And that fertility fund certificate will be also given to those members of those companies and trustees. In the export category, they will be given a registration certificate. And the proposal here is similar to the one above, to say, why don't you just exclude directors and give them a certificate of good standing? But as I've mentioned, based on experience, we will also want to deal with those that will break the rules of the markets, to be dealt with individually if the case dictates so. So it's similar to the one above, and I will request that we move to the one on section 3, G. So this one, if I may summarize, in the council, the APEC, minister appoint members of the council to in various categories, and the proposal here was to consider appointing a juristic person, in which case then it will be a company or a trust. And we are saying that we are not accepting this proposal because appointing a person in the company in the council, it will create problems, and it will be inconsistent with other pieces of legislation such as Companies Act. And we are saying that the current proposal, the current provision to appoint council members in their own right is the way to go, and is in sync with the Companies Act. We can move to the next one. This one, Chair, that is the same. We can move because it deals with the proposal of providing members with a certificate of good standing. This one also, Chair, we can move because it's the same. Yeah, the one with on the deputy register, Chair, we accept this proposal, and that the definition will be completed once this bill is finalized. So we can move to the one with the heading subsection 3.7. The phrase "a permanent resident" should be deleted, and we are gladly accepting that proposal. So is the one below. We are also accepting, Chair, that the proposal should be incorporated into the bill. Can I move to section 6, which deals with meetings of the council? That recommendation there, we are accepting that recommendation, and it should be incorporated into the bill. This one on the one below, on section 6, it's a comment, and we note that comment, Chair. If I might be allowed to move a little bit faster. On section 7, we have got no objection. We accept all, and I think we can move to section 8, which deals with the staff of the council. On section 8, this provision deals with the staff of the council. We are accepting, Chair, the proposal there, the first one, also the second one, because we think that they are appropriate and they should be considered into the bill. I request that we move, if that is okay. Okay, let me deal with this one, that on section 8, subsection 2B, Roman figure number 3, we make reference to strategic plan. So APEC annually submit, in the current act, is referred to as a business plan. And it is our intention, Chair, to change that wording to a strategic plan, so that APEC can submit a document that details the goals of APEC, the long and medium short-term goals, as well as the target that will show and the path of achieving and implementing those goals. So it's our intention that we want to change that wording for APEC to submit to the minister a strategic plan, not a business plan. If I might move to the one below, I think the proposal here was that we need to prescribe that APEC might need to procure a compilation of financial statement. And we're saying there, Chair, that it's not necessary for us to do so, because the council is obliged to compile annual reports and financial statements. So whether they do it on their own or they source somebody, that is really their decision to do so, as long as those financial statements, well audited, can be submitted to the minister. That's our position on that one. So we're rejecting that proposal. This one, which suggests on section 8, subsection 8(1)(g), we accept that one. Let me deal with this one on the objects of the council. So the one on section 9, Chair, according to our own understanding, it doesn't really add any material change to the current provision that is currently in place. So we are rejecting that proposal to include oversight and promotion of standard of conduct of agents and to regulate their activities, because the current act gives the council to regulate the occupation of agents and the activities in the market currently. So we think that that is not that will not make any material change. If I might deal with the one that deals with the, let me quickly do this. I'm sorry, I'm losing power here, so I want to connect through to my phone before I got cut here. Let me go there. Apologies. Okay, I quickly managed to sort it out. So on section 10, Chair, the proposal there was that the heading should be amended to also refer to the powers of the council. So we are saying that we believe the current provision provide for functions. So the proposal to also include the heading of that section to also refer to functions and powers will not be necessary. So if I may move to the next one. Okay. On section 11, we are accepting that recommendation, Chair. If I may request that we move to section 12, which deals with the establishment and control of the fertility fund. The proposal there, Chair, was to correct us in terms of referencing, and we think that we cross-referenced very well, and we think we are rejecting that that proposal based on that, because we think that the referencing there was correct, so it should remain as such. The next one we are accepting, Chair, and it should be incorporated into the bill. So as the third and the fourth one, if you may allow me to move to the next one, these ones we are accepting, and they should be incorporated into the bill. Okay. We are accepting the proposal that were made, that in relation to the insurance of the fertility fund. The fertility fund currently is not insured, and we made this insertion to ensure that the fund can be insured, so that it's not depleted, because this is the core of regulation in the markets, and we thought that to secure it, we need to ensure that it's insured. And the proposal that we made, Chair, we are accepting, with the exception of the one on section 12A, number 3. The proposal there, Chair, will require us to consult further, particularly with the, let me just confirm. Let me just confirm here. Yeah, we'll need to because this is one of those comments that were made by APEC into the bill last year. And we think that we will need to relook at this proposal that they are making, because it has implication, and we will need to consult the National Treasury on some of those issues that they are proposing. If I might move to section 13, which deals with the payment out of the Fidelity Fund. The first proposal, Chair, we're accepting that proposal from stakeholders, and it should be incorporated into the bill. Subsection 13, section 13(2)(b), Chair, this is similar to the one I've just mentioned there. If you could look at our response there, we're saying that consultation with the National Treasury are required and necessary in order to interrogate the recommendation for a determination to be made, and on whether the accept the recommendation and or reject, because that the nature of that proposal will really need us to relook and consult our colleagues at the National Treasurers. So I request that we move, Chair. The one on section 13, also similarly, Chair, it will require us to, as the department, to relook at this proposal and maybe just to put it into context, because maybe this will come a lot as we go. Our initial process in drafting this bill, we did it intimately with APEC, and they made profound amendments as the regulator into this bill. But through the passage of time, Chair, the loopholes of regulation will be detected by the regulator, and as and when they see that, they made those proposal into the bill. So hence why, from the department side, we think that we need time to really look at this proposal that APEC is making and reconsider them, whether now or in future amendment of this bill. So yeah, that I thought I should give context there, because it will come often, this recommendation, this response. So similarly, on this one that appears on the screen, this falls under the category of those that will need to look at these proposals, Chair, with the context that I've given. I request that we move down. Similarly, okay, we can deal with this one. On section 14 deals with the claims against the fund and actions against the council. The proposal there was that the person submitting the claim must do so under oath, and the affidavit should be deposed by the person with knowledge. Our response there, Chair, is that we're not accepting this proposal. It should be considered it should be considered is one of those proposals that need to be considered in the rules, because Section 22 of the Act provides for APEC to make rules, the procedural rules of how things should be done on a daily basis in executing their work. So this should be dealt with in the rules, not in the Act, Chair, as we understand. Similarly, the second one is quite a technical issue, which we think that it should be dealt in the rules, because it deals with the calculations of the claims, and the proposal there looked at the limitations of that, and we think that it should be looked at into the rules, because our understanding is that once this bill is signed into law, APEC will be required to amend the rules of the three categories of agents, and some of these proposals that are made here, Chair, can be incorporated into the rules. So these three comments I will request to pass, because of the content that I've provided. If we may move to this one. Let me see. This proposal, Chair, on section 14.3, subsection 3 and 4, it was based on the earlier proposal in clause 1, where we were requested to cluster the definition of agent into one. So because we have explained that it's not our position to cluster them, so I request that we move, because I've answered to that one. Similarly to the one on section 14.5, I request that we move to section 16. This one deals with the prohibition of acting as an agent under section circumstances. The proposal there, Chair, we are rejecting this proposal on the basis that these are also some of those issues that will need to be dealt with in the rules. And we had a discussion with the APEC as we are drafting the bill, and they also accept that these are some of those issues that will need to be dealt with in the rules. Section 16.1, Roman figure number 1 there. This one is also similar to the definition of an agent in clause 1. We can pass, Chair. I've already answered this one. The one on section 16.2, we're accepting this recommendation, Chair, and the one on Roman figure number 2, which says the reference to an agent should include further reference to employees. We are not accepting that definition because the definition of agents in the bill include employees who act in that capacity. So we think that we have already made this. This proposal is already there in the bill, so we reject that on that basis. I can move to the one on section 16.3A, B and B. We are not accepting this one because these are one of those that need to be dealt with in the rules, and the APEC will do so once this bill is signed into law. Section 16.3C also falls under that cluster of technical issues that will be dealt with in the rules. May I request that we scroll down? Yeah. Section 16.3E, also it should be dealt with in the rules, so is the next one. And the other one that comes, may I request that we pass. These are technical amendments that should really be dealt with in the rule because they are procedural in nature. The one on section 16.6, A, B, and F, these are one of those, Chair, that we request that we should be dealt with in the future amendments, or those that the department will need to relook at them to reconsider the proposal that was made by APEC, there, Chair. So may I request that we scroll. Similarly, this one will look for legal opinion to inform our decision as such. And the one on section 16.6I, paragraph I, we accept that recommendation, as well as the one with subsection 6J, we accept, and those should be incorporated into the bill. Yeah, we can pass this one's, Chair, because I've provided context that these are one of those substantive amendments that will need to be reconsidered by the department and APEC in future. I think we can go down. Yeah, let's okay. There's section 16, subsection 6A, capital letter A, B. This should be accepted and should be considered in future amendment, Chair, because the proposal there is quite good. We look at it, but we should cluster that this one with those that should be considered by the department and APEC in future amendments. Section 16.9, the recommendation there is not accepted, Chair, because the definition includes an agent as a person who acts on behalf of another, and this we've included it in the definition in clause 1. We can move to the one below. The Roman figure number 1, it says subsection should be included to report further particular of changes in agent email address and mobile telephone number. We are thinking that this kind of proposal, Chair, should be considered in the rules, so we're not accepting this proposal. And for the one on Roman figure number 2, we're not accepting because the definition of the definition include an agent as a person. So we made that clear. So that proposal there, we are not accepting it because of that reason. This one on section 16(9)(b), paragraph number 6, it should be clustered with those that the department will look at them accordingly to reconsider them in future amendments or current amendment. But we need to look at the proposal because they are good. We will want to consult further on those provisions there. So that will be for the one on section 1610A and the one that followed there. So may I request that we scroll down because the context is the same. Section 1610. These are the proposal that we think that should be dealt with in the rules because it deals with the lapsing of a certificate that will have been issued by APEC on termination of employment and when a director or member ceases to act as such. So these are one of those procedural matters that should be dealt with in the rules, Chair. This one. Okay. This one, we should cluster them with those that will further engage. Chair, may I request that we pass together with the one that follow. Let me look at this one on section 6. Yeah. Okay. Section 16, subsection 15B, 16B, those are those proposals that were saying that we need further engagement, Chair. So if you may allow me, I request that we move for and section 16, 21, 22, 22B, 23A, and 23B, we accept this proposal and we think that they should be incorporated into the bill. Yeah, so I propose that we move with it. Proposals on section 1629, which is a new insertion by APEC, Chair, it's not there in the bill. We think that these are some of the proposal that needs further engagement and reconsideration. So that it's the same for the proposal on section 1681, which is a new insertion. Similarly to the proposal made there on section 16.1b, those are okay. Let me deal with this one. Yeah. Okay. Okay, the proposal or the concern here, it was saying that it seems that the trust have been excluded from practicing as fresh produce agent. And the recommendation, Chair, there is not accepted because the deletion seeks to remove the implication that the said director or member or a trustee only need to register if he or she act as an agent, which is not the case. It does not imply that trusts are excluded from practicing as fresh produce agent. There is just a particular wording there that we are removing, that we think that it's really shouldn't be there. So we're just removing that part, but we are not excluding trust to practice as fresh produce agents. So we can scroll up. And this also is similar to the one above. We're saying that the bill does not provide for the exclusion of trust in practicing as such. So we can move. Okay. This one on section 16, subsection 6H, it was with the proposal that the basis of this deletion, that is the compliance with liabilities to the council, is uncertain, and it is proposed to be reconsidered. And our response there, Chair, was saying that the recommendation is not accepted. Section 16 provides for circumstances where a person is prohibited from being issued with a Fidelity Fund certificate. And Section 16.6H provide that one is dealing with a person who is already registered with the council and who has failed to discharge his or her liabilities to the council. And Section 16, however, does not deal with a situation where where someone has already been registered with the council. So we're just making it clear for those that it's not clear to what we want to do there. Okay. The proposal on this section 16, 6M and 17B, it was in relation to past APEC to comply with PAJA, as it is proposed that an appeal procedure be included in the form and format prescribed by PAJA. And the recommendation there, Chair, is accepted. And clause 1427 is specific in the case where certificate will lapse after an approved by APEC. It is also understood that the reason for refusal here is based on a failure to issue the certificate in the first place. It therefore do not make any harm to include providing material reason for refusal, which will be in line with PAJA processes. So we are in acceptance to that proposal then. The proposal on section 1625D, we are accepting that proposal that was made, and we recommend that this proposal must be inserted into the bill. Section 1613M, it also deals with the processes of PAJA, which we have spoken about above, and we are accepting that recommendation, and we are just outlining the processes there in our response and in agreement with what the proposal is saying there, Chair. So we are accepting the proposal and it should be incorporated into the bill. This one says proposal of certificate of good standing. If the proposal is accepted of issuing certificate of good standing is accepted, then distinguish between registration certificate issued to legal entity. Chair, we have dealt with this matter of this proposal, which we have rejected above, and we think that this is a statutory requirement, and agent must comply with the requirements there. I think the extension of it says failure. Okay, let's move. Okay, this comment here, it says this provision requires all directors, trustees to also be issued with a certificate, not only as defined. We have dealt with this one, Chair. I request that we move because it deals with the response that we've given, that we want to extend regulation to individual members and directors. Yeah. The comment there that appear in our screen is related to the above, and so we can move. And the next one with relate to POPI Act, the comment above, we have noted that. The last comment on section 16, Chair, is not related to any of the amendments, and we thought we should just respond as such because it's not part of the amendment. And
5 minutes. Can we conclude?
Okay. Can I request to move to? Okay, let me deal with this one. Section 17 deals with the security that the agent needs to issue to APEC as part of the requirement to be registered as agent. This proposal, the Chair, is not accepted because the calculations of security there is dealt with in the rules, and it should be even now it's very clear what it wants to achieve, and is there. That is why we put the Gazette where it is for everyone to make reference. And it should this act be signed into law, it will be also amended by APEC. So I request that we move to the next one. We have dealt with this one, Chair. I request that we move to, because these are repeated comments, I request that we move to section 17A. Yeah. So, Chair, this was dealt with in the presentation, section 17A. Yeah, where let's scroll. It was dealt with in the presentation that was made by DG and the edition of Mr. Msese. We are conceding here, the Chair, that although our intention was very clear that we want to protect the interest of the producer, but we think that at this moment maybe this proposal should be left to the producer and an agent to look at that kind of an arrangement. Maybe for future we might look at it, but for the purposes of this bill, we think that is not. We should just accept the proposal to remove that insertion. I request that we move because this is we make a total acceptance. Section 18 deals with the accounts. If I might be brief, that comment there on section 18 is the recommendation to adhere to provisions of the Companies Act with respect to audit. And we're saying export agent trading in the fresh produce market are required to comply with the Act. So we have dealt with this one above. I request that in the interest of time, we move to the next one, which deals, let me see. So the comment on that Roman figure number 2 and 3, yes, Chair, we're saying that the APEC and the department understand that the bill intends to limit confusion by clearly defining the 3 categories. We've dealt with it above. I request that we move to section. We have accepted here, Chair. Section 19 deals with trust accounts, and we accept that the first recommendation. The second proposal there we're not accepting, Chair. The one on the Roman figure number 2, we're saying the provision for opening trust account for producers is intended to protect producers. So we've dealt with this one clearly. I request that we move. Okay. We can move here, Chair. Okay. Section 19, Chair, was covered in the presentation. It deals with the producer trust accounts for export agents. I propose that we move, because this was covered and our reasoning for it to remain here. We've advanced our responses. Okay. Section 20 deals with payments from trust accounts. The proposal was to reference to fresh produce agent should be amended to agent. This was dealt with in clause 1 because it's the proposal to cluster the three categories into one definition of an agent. We have dealt with this one. And the second one on that section 20, we will request for this to be also clustered into those that the department will need to further engage, because it's a new insertion. It's not there in the bill. So can I move to section 21? Okay, section 21 deals with the disposal of unclaimed monies. That comment there is noted, and APEC follow normal fair consultation process when it wants to amend the rules, and also in this process of amending the act. So can I move to this one? The recommendation, okay. Okay. Amendment of section 22, which deals with the rules, the requirement that council must publish rule for public comments and must consider any comment received. We are saying there that in considering the review process of the rules, APEC make the process very transparent, and everybody has the right to make their inputs, and the input will be considered. So it deals with the process of amending the rules. So is the next one, Chair, which seeks transparency in consultation in amending the rules. Okay. So this one was dealing with the rules in respect of export agent, and was saying that it is foreseen that the rules in respect of export agent published in the Gazette will be redrafted once the bill is approved, and the reference remain correct at the moment. If I might move to the next one, which deals with providing powers to the minister to approve the rules. I think the proposal there was that this might cause a constitutional problem, as the line of administrative powers will be blurred. And our response is that the approval of subordinate legislation is delegated to ministers, and section 22 gives the minister power to approve the rules of agent, and we think there is no constitutionality problem there, and no political influence as proposed there. So this one deals with, let me see. So this one and the next one, the last comment on section 22, we can cluster them into those that the department needs to further engage. So I request to move to section 23. So the first comment was responded to above. And the second one was saying that that recommendation is not accepted, because subjecting that proposal to that clause to one piece of legislation will be limiting, and we think that the way it is now is correct. And section 24, that recommendation is not accepted, because adding the word reasonable will create confusion, since reasonable will vary from one agent to the other. So that's our understanding and the reasoning for rejecting that proposal. Section 24, 22D, the recommendation there, Chair, is not accepted. The decision to approach the court by the register is based on the determination of significant prejudice or damage to principle, imminent or actual, and given reasonable time might expose them to further damage. That's our response to that proposal to add reasonable time. And the proposal there on the next one, add the word deemed on behalf. It's not clear. We're not sure what it seeks to achieve. So we think that is not clear. We pass. Section 24, add the word reasonable. And we are saying this proposal is not accepted because by notice implies that it must be in writing.
Thank you, Ntate Mokoena.
Thank you, Chair. Thank you very much for your time. And gladly take any question that comes. Thank you, honorable members.
DG, thank you for an in-depth presentation and responses. I am looking, honorable members, 81 pages on that responses. And I think if we continue at this pace, we may never come around to asking and covering questions. So I would like, rather than finishing the presentation, which we have had time to read through, to rather spend the remaining time of our committee meeting just to engage with the document and the responses from the Department of Agriculture, Land Reform and Rural Development. We will now open the session, honorable members, for questions of clarity or comments. Honorable Kape.
Thanks, Honorable Chair. I've been kicked out for some time. Luckily, like you say, we have the document with us, and I'm struggling with load shedding. I'm in load shedding here. But Chair, let me welcome the response from the department, and I would want to summarize on the issues that they have alluded to. One could just notice, like we said during participation, that entities or organizations that came to present, especially for oral submissions, were APEC affiliates. And this is the question that we asked because they were talking more or less the same thing. One, Chair, the issue of protection of producers still stand out, and it is our responsibility as government to make sure that they are protected. And that brings the worry, Chair, that this bill has been there for 7 years now without being processed. And I'm wondering, those that needs to benefit, what are they saying about us? Technically, Chair, for me, there's a balance on responses, on acceptance and non-acceptance. And foremost, I was guarding this 1 year insurance because if we had to lose markets, then it would not deal with the mandate of this department. And I'm happy that the department has accepted that proposal on issues of insurance so that those markets still stay there. And I wonder, Chair, how will the department deal with this thing of now the producer having to deal directly with the agent so that there's no exploitation? But Chair, out of everything that has been said, I want to track the interaction with the sector or the industry with the department when they started this bill, because the oral submission wanted to suggest that there was minimal interaction with them, as if they did not know where this thing started or where is it going. It was more like lamenting to the committee to say, please help us. Whilst on the other hand, we need to balance. And for me, the balance that they said, playing field is not balanced. Today, I get a sense that there is balancing because of acceptance and non-acceptance here and there. So I want to know from the department, how did you start when you introduced this bill with the sector? Was there interaction with APEC? And how was why all of a sudden it's like it's a new thing to them? Two, Chair, the presenter indicated that some instances they would want to do legal consultation on some aspects on where they are not sure. When will we get response on this one? Because on our own, after their response, we need to consider the report before us and their responses so that we are able to make an informed decision on this bill. When will they get this legal advice and how will it get expression on what we will be dealing with? That will be my submission, Chair. Thanks.
Thank you, Honorable Kape. Honorable Mamustein.
Thank you, Chairperson. I'm sorry if there's a bit of a noise in my background. I had to move due to having troubles with my connectivity, so I'm near a workshop here on the farm. Chairperson, yes, I share the sentiments or the concerns that Honourable Klape just spoke about. I am extremely concerned, Chairperson, that this bill was first published in 2013. So it's actually 9 years in the making, if I'm correct in that. And I asked that question specifically to the role players of what was the interaction with the department before the bill came to Parliament. Because it's clear if we read, Chair, all the comments and the concerns that the role players had, and even listening to the department today clearly, and unfortunately I didn't count the sections, but the words that said is, when we amend the bill again during next consultations, it spells out one thing. The department sat on the bill, pushed it to Parliament quickly to come and fix it so that, it's now in our hands to get it right. But they didn't meet with the industry. It was clear, Chair, that we could have taken maybe a month or two longer, met with the industry and brought a bill to us that was acceptable to everyone. Chairperson, so to me, I'm really very concerned about this issue, and I would like to make a recommendation, Chair, that we either the department retracts the bill, take it back, fix it with industry, do all the things that they have said today to us during further consultation and during the next amendments. Do it now. Let's do it and fix it one time so that we don't agree on a bill that in next year we say we need to fix certain things. Either they do that, Chair, or we take the bill as a committee bill and we then have further consultations with the public and we fix the bill properly one time. Chair, but I would propose that the department retracts the bill, fix it properly and bring it back within 6 months so that we can pass it, Chairperson, with proper consultation with industry. Thank you.
Thank you, Honorable Stein. The Honorable Ntate Matiasa.
Well, thank you so much, Honorable Chair. Greetings to fellow members of the committee and the presenters from the department and other stakeholders. Look, what is worrying really is that once more, Parliament has been proven to be ineffective in processing legislation and ensuring that there is a sense of stability and confidence in the sector. That's the first thing. The second thing is that the only way that there can be predictability of what the sector is doing is only if there is an effective legislative oversight on a regular basis, which is lacking in this case. And the two factors really talks to one thing which is a primary concern for most of us, that for the longest of time, this sector has remained untransformed, and precisely because there's been no effective legislation, there's been no effective oversight, and ensuring that there is a thoroughgoing transformation in this sector. And lack of transformation means that the sector remains lily-white, the sector remains white and male-dominated, and it stands no chance of ensuring that Black people and Africans in particular find expression in whatever that is happening in this sector. So until such time that a legislation of this nature, which has remained obscured from the public domain, and members of parliament have not been taking it seriously, the issue of transformation or the transformation agenda in a critical sector such as this one will remain evasive for majority of our people. It's important that this legislation addresses the question of transformation and ensure that by transformation, people with disabilities, women and youth, previously disadvantaged groups are catered in this. And should there be no practical work towards ensuring that there is transformation, Honorable Chair, I'm sorry that would be repeating what has been repeated in the last 27 years, and later would also be sitting again, seeking another amendment on a bill which we could have ensured that finds thoroughgoing expression of the deeper needs of our people in a way of a transformative agenda. Ngiyabulela, hlale sihlalo.
Thank you, the Honorable Ntate Matias, the Honorable Mamuchwete.
Chairperson, the fact that the department is saying to us there are certain legal opinions or certain they still need to conduct or to consult. Therefore, I'm asking myself, for 7 years, you've been consulting. Nevertheless, Chair, this bill indeed is really important, more so to the actual farmers. I wouldn't like, Chair, that as the committee we just tick the boxes. Let's do due diligence of what needs to be done. And we do it properly. Firstly, Chair, let me register that the fact that the bill is a bill of 1992, for me, it's good that it should be amended so that it can be in line with our constitution of the democracy. But with what is presented to us, we won't be doing justice to it, Chair. I would recommend also, Chair, that we allow the department to finish with the consultation, and also, Chair, to further invite other stakeholders, because to me, I'm not convinced that they've done justice in terms of consultation and the stakeholders involved. Thank you, Chair. I agree with the latter speakers that let's allow the department to finish this thing and come back to us. Thank you.
Thank you, Honorable Mamuchwete. Honorable Mamumbabama.
Enkosi, Chairperson, I just have one question for the department. And my question is, what motivated the department to table this amendment bill to Parliament at this particular time, considering that not all recommendations were sufficiently consulted, researched, interrogated? What informed the urgency? Thank you.
Thank you, Honorable Mbabama. Agbare Breed.
Môre voorsitter, baie dankie. Chairperson, maybe let me start by seconding the Honourable Steyn. A lot has been said, and I will go to my question now, but I do think that the department needs to retract this bill. They need to go and do their homework, as I think Honourable Schlapi and all of our previous speakers have said. In Afrikaans, I almost want to say, hierdie wet is halfgebak. And I think that they need to go do their homework, they need to consult, they need to take the stakeholders into confidence, and all that they have indicated today, they do accept or they don't accept because of rules or this or that, and that they do. But Chairperson, maybe let me get to my question. But I think, yes, I think the committee has been quite clear, and I think they need to go back and do their homework. But Chairperson, maybe to get to my question, the department has been selective in its answers. It did not respond appropriately to the issues that have been raised by stakeholders through written oral submissions. Lack of consultation and engagement with stakeholders has come out quite strongly. SAFPRO, for example, highlighted that between 2012 and 2017, there was a joint and thorough process they were involved in with the previous registrar of APAC. And apart from the issue surrounding credit insurance, that process accomplished a proposed amendment bill that provided the required protections without undermining the industry. SAFPRO, including other stakeholders, further reported that the proposed amendment bill before Parliament has been introduced in its original form from 2012-13 without considering all the work that was done between 2012 and 2017, including the impact that the original proposed bill will have on the industry. The department did not clearly respond on this, except to mention that the bill was advertised in 2013. Public hearings were held in 2015. The department this morning sent us some background documents on consultations. However, this document sent this morning makes reference to the Agricultural Produce Marketing Agencies Bill of 2013, not the Agricultural Produce Agents Amendment Bill that is before the committee currently. The department should please explain the confusion and further indicate whether the consultation on this bill that is before the committee was done and when was it done. I will leave it at that. Thank you, Chairperson.
Thank you, Agbare Breed. The Honorable Memahlatsi. Honorable Memahlatsi. Honorable Memahlo.
Good morning, Chairperson. Excuse me for my video. My network's not too good. I would like to take this opportunity and say to you, good morning, Chair, and all honorable members on the platform, including our officials. Chair, as much as for this bill, one would like to indeed acknowledge the work done by the department up to so far. Although it seems like as if they did not do enough, as there is a word where they are saying they still need to consult with the legal team. It means that the work is not finished. We commend them for the work that they've done up to now, but they must indeed do, as other honorable members have already mentioned. I'm supporting what Honorable Hlape has already mentioned and Honorable Chete, including Steyn and Honorable Steyn and Honorable all of them. Breathe. Let the department go back and make sure that they work on this bill and bring it back to us, being refined, so that we can be able to take the well-informed decision. As much as we commend their work, that according to when I was listening when they present, yes, some of the points that they've raised that they did not agree with, they are the good points because they are preventing, they are helping the South African people they're preventing fraud in the other way round. That should not happen, because if we don't take this into consideration in future, we can see where the world is going. There will be certain people who are owning certain things, where there will be even owning people who are working in the farms. So I think somehow, the bill somewhere, it has good points, though they must go back and finish. It's long that the bill is on the table. They must just make sure that speed up, so that when we go in 2014, the bill it must be already passed by Parliament so that it can work, because it's long overdue. Thank you.
Thank you, Honorable Memahlo. Dabezita, Nkosi enkulu. Honorable Sabekulu had earlier announced that he may have to leave earlier to join a mini plenary. And also his network was running low due to not being able to access electricity since yesterday. Honorable Ntate Masipa.
Thank you, Chair, and good morning to our colleagues. Chair, I think most of my colleagues covered me, but I just want to maybe just re-emphasize again some of the salient points. You know, the department kept on using words such as accepting the proposals, require more consultation, we'll look at them for amendments and consult further, and that they need further engagement. So in as far as my little understanding about how we work with regards to bill is that once the department introduced the legislation to the Parliament, it becomes the committee's bill. So this, what has been mentioned by the department, it means that they introduced this legislation without really completing their work. So I do support my colleagues that, yeah, seriously, I think they need, maybe we need to request them that they finish their work first. And once they have done, and they can come to us, because, you know, our invitation of them today was just really to ask them to give us their perspective as the implementers of this particular law. And it was important that the department respond, but don't overstep their role in terms of, understanding how to separate, their role between themselves and the committee. So their part, in my view, was completed. So the amendments and all those other things was now in our hands as the lawmaker to start looking at those things. But further, Chair, something that I just want to caution, while I agree that, and support and second that the department retract the bill and go redo it, I think, the bill, the department has to be really very, very careful about this particular bill, because in my view, it can create a very big monopoly of producer exporter-led industry, whereby the small emerging farmers will not really have the opportunity to participate, especially in the export market, because of tighter regulations. And I think it is very important that the department really, when they go back, look at this, really go deeper into looking at the market, the transport, the shipment, the regulations, of various countries, and the financial instruments and regulations, both locally and internationally. I do support one of the views that was said, that maybe you need to look at a bill that really focuses local market and one that focuses the export market, because the export market is really, really very, very complicated. And I do applaud that they have made a concession that the insurance definitely is going to kill the market. But I do feel that strongly, Chair, that consultation needs to take place, and it needs to really go deep in engaging on this matter. Thanks very much, Chair.
Thank you, Honorable Ntate Sipa. Honorable Ntate Kapa.
Thank you very much. As much as I share, especially the sentiment that all those issues that still need consultation should be done as fast as possible, because it's not helping if we continue having a bill until we leave this parliament without completed this legislation, which was aimed at achieving something. But my question, I only hope it is within the understanding of this bill. I would like to know from the department whether there are some things which are just too tough, or on the opposite side, just too loose, or it's just a mere coincidence that the presentations and the implications of this bill, from the presentations of the inputs, it indicates to me that to a very great extent, it is a predominantly white sector, which might have implication in future when this committee is regarded as having appreciated and approved a bill which was having glaring signs of non-transformation. Not unless maybe this is not relevant, but I do have that concern. Maybe if the department can explain that no, the bill has nothing to do with this, or there's nothing that can be done in the bill to redress this. This is a norm or natural phenomenon. I thank you, Chair.
Thank you, Honorable Kapa. Honorable Ntate Muntwedi.
A very good morning to you, Chair, and all honorable members in this platform. Chair, I share the same sentiments as shared by members of the Portfolio Committee, but I do want to put 2-3 issues so that the department actually looks at some of those issues. I just wanted to check on the side of the department on how does this amendment that they are bringing ensure that, because there's where they said that agents do not share the responsibility that is shared by farmers with regard to as a result of loss. I wanted to check how does the amendment actually address that issue. And then also to say on the part of the growers, producers, how are they affected by the insertion of the Fidelity Fund into the bill? And then also, Chair, to say correctly, it's important that there should be interaction with relevant stakeholders in the sector, as this would actually eliminate any issues of concern. Since this is a technical bill which would actually requires participation mostly of those players that find themselves there, Chair. But with that, thank you, Chair.
Thank you, Honorable Muntwedi. The Honorable Memahlatsi. Memahlatsi. Honorable members, is there any other honorable member who have not recognized who may wish to pose a question? If not, thank you, honorable members. And before we hand over back to the department officials for responses, allow me to pose a question or two. In respect of the producer trust accounts, Stakeholders have highlighted, honorable members, that the rules do not take into consideration the commercial aspects of the export industry, which makes the implementation of this rule impossible. It was explained that the very nature of the business is that each overseas market and client has its own and very different terms. In many instances, honorable members, exporters disperse funds to service providers, shipping lines, and producers or growers in advance of receiving the funds. The AAM livestock agents and auctioneers, for example, have highlighted that trust accounts are not required for most auctioneers, as auctioneers in KwaZulu-Natal, for example, pay the sellers before collecting money from their buyers. Therefore, the financial risk is borne by the agent or auctioneer, which renders the use of a trust account inappropriate. Honorable members, since the department insisted that it feels strongly about the introduction of the trust account, how does it therefore plan to address the different aspects of the export environment and livestock, as well as auctioneering industry? How does it propose to implement such a clause in light of the challenges that have been highlighted by the different agents without collapsing the industry? Secondly, honorable members, there was a recommendation that the obligation for export agents to comply with local fresh produce agent requirements should apply only if fixed threshold is exceeded in terms of local volumes supplied. What is the department's view on that? Lastly, honorable members, if the department has emphasized the bill's intention to protect farmers, in this regard, can the department submit to the portfolio committee a detailed list of the different farmer categories that have access to fresh produce markets, export markets, and auctions, including how farmers are able to access these different markets? Thank you. DG, Dr. Ramasodi, over to you and the officials of the department for responses.
Thank you very much, Honorable Chair, and thank you very much for the inputs that have been made by the Portfolio Committee on this matter. Quite welcome. It was also my understanding, Chair, as you have rightfully indicated, and I think Honorable Masika at some stage also indicated, that the bill was now in the hands of Parliament, and Parliament would be guiding on the issues, and we take the guidance that has been given by Parliament. But a few issues that have been raised that would require us to have detailed responses. Maybe let me start with the unit that is responsible for this, and I'll conclude with the other features that I thought were very important in terms of our department's response on the issues that members had raised, to say maybe the department would have not done the homework accordingly, and I'll conclude on that one. I'll ask Mekwena to rally her troops around the responses, and I'll wrap up, Chairperson. Thank you.
Thank you very much, TG, and thank you to the Honorable Chair. Honorable Chair, I'm going to request that I come after my colleagues in responding to some of the issues that have been raised by the members, And as the DG has indicated, we really do welcome this. But as a general comment from my side, Chair, I just want to touch on the issue of there was an issue which was raised with regards to rushing the bill to Parliament, and also indicating that there are some issues that says they need further consultation or they will be dealt with at the next review of the bill. Chair, I would like to indicate that most of these comments that were made by the department with regards to review at the next sitting, at the next review, dealing with the issues at the next review, or we need further consultations. These are the issues that just came at the tail end of the process. And in order for us to look at them and see exactly what they mean to the bill, there are implications to the whole bill, we really have to apply our minds. And as the DG has indicated, we will be guided by your good selves, Honorable Chair, as to the time frames that we will require. So in essence, I'm just indicating that it's not from our side where we just sit and say we want to continue with amending the bill at a future stage, but it's just that the comments came at a very, very, very tail end, very new, and that's why we say we would like to consult on them. There was an issue that was raised by Mayor Briere as well in terms of consultations with APEC. I'm not aware of the department being part of those consultations. We do not have a report on those. And in as far as the consultations which were dealt with by the department, we have clearly outlined them, and we can even provide the minutes. And on those that Mayor Briere has alluded to, we don't even have the minutes. My colleagues can correct me if I have missed those minutes. Chair, can I perhaps at this stage, Chair, hand over to my colleague, Ntate Mosese, who is a member of the board, to just clarify on certain issues, Chair. Ntate Mosese and Ntate Kelembe, I would appreciate it if you can just come in.
Thank you.
You may proceed.
Yes, thank you, Chair. Okay. Let me make a comment relating to the consultation and related to the Agencies Bill 2013 versus the bill that we are currently looking at. From 2013, when we published the bill, to date we have had a number of engagements with, let me start with the consultations first. The bill was published and it was also sent also individually to various stakeholders within the sector. Even after the publications, there are those that we have identified and the bill was forwarded to them. And the role players at that stage were requested to indicate whether they would like to have oral engagements with the department on the bill. And after receiving the intentions from role players, we arranged meetings or the consultation sessions. We had quite a number of sessions with various stakeholders where they made oral submissions relating to the bill, their opinions, and they also wrote to the department, and their comments were considered when the bill was being prepared over the 7-year period that has been referred to. And of course, from our side, we also have the report relating to the consultations that we have made. So now let me come to Agencies Bill 2013 Versa V, what we are having in front of us. It's basically the same thing, because during development phase, we had a number of interactions with the Office of Chief State Law Advisors. Initially, the intention was to amend the Principal Act. We were advised to actually develop a new bill, which we developed and published in 2013. So following the publication, like I said, consultations took place. Thereafter, we re-looked at the bill based on the comments we have received. After that, we consulted the Chief State Law Advisors again regarding the bill. Then they came with a second advice again now to say, no, maybe the agency's bill that you have here, please let's rework it, let's turn it into an amendment bill instead of doing the new bill altogether. So based on the advice from the state law advisors, then we went back and turned the very same document into an amendment rather than the new bill. So the two, in terms of content, there is no difference in terms of direction that we would like to take with this legislation. There's also no difference, because the only thing was that, no, maybe this might not be the correct way. Let's rather make it an amendment. I think the only thing that has changed, the only major change from that one to this one, is regulation of the market facilities, because on that one we were advised by the state law advisors that no, that one would be in contravention of the Constitution, as it encroaches in the local sphere of a government. So all those comments were taken into account, and that is basically the background that led us to where we are. And like I said, in terms of content and the direction, it's basically the same thing, but there were legal considerations by the Office of Chief State Law Advisors, and we had to take those into account. Hence, it was changed into an amendment of a new bill. In terms on the issue relating to how does the bill address the loss by farmers, because indeed the environment where they operate is quite a risky environment, and it is indeed correct that the farmer is actually more exposed in that environment as compared to the agent, because if any loss takes place, then the farmer has got a problem. If the gains are realized, then both, they smile all the way to the bank. So the bill itself actually protects producers from one possible occurrence that might be perpetrated by the agents themselves, and that's theft or dishonest conduct. if the farmer supplies to the market and they lose their produce because of theft or dishonest conduct by agents, then the bill empowers APEC to intervene, investigate the agents, and make sure ultimately that there is a recourse for the farmer. I think that's how the bill basically protects the farmer, and we acknowledge that there are other aspects or other eventualities that may lead to losses, and unfortunately, currently there is no any legislative instrument governing those, because when you talk on issues like quality deterioration, I mean, farmers, it's possible that they may lose the produce due to quality deterioration, especially when their produce sits on the market floor. So in terms of those kinds of eventualities, the rules that are published by the minister provides that agents need to communicate within certain time frames with producers to alert them of anything that is occurring on their produce. If their produce is downgraded from grade A to B, such information must be communicated with the agent, with the farmer. If there's a risk that the produce will go to rot, the agents are also compelled by law to inform the farmer well in advance that the farmer can reconsider their options, maybe direct the produce from that particular market to other channels that may sell a little bit quicker. The issue of the trust only now being proposed for export agents in the current bill and not the livestock agents. I think there was already a view from one of the members that well, the export, I mean, the livestock agents have already highlighted that the trust on their side may not be necessary, mainly because when they conduct auctions, they do it on the spot. By end of auction, then everyone gets their check or they get paid for what was sold. So at the auctions, it's more like the produce or the animals are sold in the presence of the farmer. So hence, even initially, there were no issues in terms of the requirements for livestock agents to have a trust account. Yeah, I think so far that is how much I can bite on my side. Let me thank you very much and hand over back to colleagues. Thank you.
Good afternoon, or good morning, Chair and honorable members. With your permission, Chair, I have been asked, this is Tembele Kelembe, I have been asked as well to take some of the questions.
Please go ahead, Dr. Kelembe.
Thank you, Chair. Chair, I just want also, I think my colleague, Mr. Musese, has covered quite a number of issues that have come up. But just to go back again to this issue of the trust account, particularly when it comes to the export agents. What the department's intention there, Chair, is, as we have stated, to protect the producer whose produce is with the export agent. The reason why we we are going the route of a trust account is to provide for instances where there is a problem with the particular agency, that perhaps there may be an attachment of the agency's account for whatever reason, going into liquidation or those kinds of mishaps that can happen in business. If the money that should be belonging to the farmer is within the business account, then the problem is that if such a mishap happens, then the producer has no protection in terms of what is due to him or her. So that is essentially why we are going for the issue of the trust account, even on the part of the export agents. But the sentiment seems to go now. If there are alternative ways of protecting the farmer, the department is definitely open to such suggestions, and those will be considered if indeed the portfolio committee does give the bill back to us to work on some of these issues. I think the issue of the agricultural produce marketing agencies bill and the difference between that bill and this amendment bill, the agricultural produce agents amendment bill, has been covered by my colleague. And the issue of consultation, yes, indeed, there have been consultations with APEC. I do hope that my colleagues did point it out right at the beginning. Unfortunately, I had serious problems with connecting at the beginning, Chair. That's why I connected very, very late. And the issue there being that the consultations that happened, because of the length of time that it has taken for this bill to be where it is now, it so happened that the registrar of APEC, who was there at the beginning, unfortunately, is no longer there. So we have a new, in inverted commas, a registrar at APEC, as well as the council itself, if we talk of the chairperson of the council. So that is the gap, perhaps, that has led to this feeling that there hasn't been much consultation with APEC. Yes, indeed, we have consulted, and we continue to consult with APEC on the developments on this bill, Chair. Yes, Chair. I think those are the other issues, Chair. When I look at my notes, I think have been covered. But yes, I can come back later if there is any other issue, Chair. Thank you.
Thank you very much, colleagues. Thank you. Over to you, DG. We are done on our side. Thank you.
Thank you very much, Meko Mape. Thank you very much, Chair. Honorable Chair, I think the only issue that is left is the issue around the consultation part that maybe Mr. Gelembe has given clarity on. That the current issue that we are seeing is a contestation of what was agreed by the then registrar and consulted broadly, and what is happening at the moment, because most of the issues that are here were part and parcel of that discussion with the previous register. Honorable Reid refers to the inputs that were made at the portfolio committee during the consultation. I would like to refer to an input that came, I think, from the deputy registrar on the issues where they were themselves as the council making admission that they wouldn't have known what the previous registrar was engaged in and how this comes through. But there's that element that comes through that the current council, especially the subcommittee within the council that deals with export agents, that is currently also, according to my own analysis, addressing issues around export agents and have got a few export agents represented, has got a view around the bill which would need to be looked at. Some of the issues that came through, honorable members of the Portfolio Committee on Agriculture, Land Reform and Rural Development, some of these issues are actually very new issues, and it becomes very difficult, even if maybe the department would have done a broader analysis to respond to issues that would have not been brought to the table during a particular period, and therefore would not have been considered. And it would be, from our own perspective, a futile exercise if we don't test the veracity of what is being proposed, because some of these issues might be solutions for us. But I would like to end off, Honorable Chair, to say that we, as the sector, we have been here before, where there has been divergence in terms of how a particular bill is being viewed, and this bill has been given, and there were issues. I would like, if the decision is taken, a very strong indication that is coming from the portfolio committee on the expectation for the bill to come back very early, because the department would not like to be at a point where there are delaying tactics that are being played within a broader perspective of consultation, which prevents us to come earlier to Parliament as instructed. Thank you, or would be instructed. Thank you very much, Chair. We would like to thank you and the Portfolio Committee for the inputs that have been made on the bill. Thank you.
Thank you, Honorable Ntate Ramasodi, the DG, and the officials of the department, Memokwena, Ntate Kelembe, as well as Ntate Musese, for your responses. Honorable members, there's the responses from the department in terms of the public hearings report that was sent to them for responses. We did have other items aligned on today's proceedings, but with the limited time we have, we will not be able to do justice to that work. We have honorable members, our oversight visit report on the ARC and the OPP that we wanted to peruse through and have adopted. And we also have the minutes of the portfolio committee that we would like to get through as well. But I think since we have 10 minutes remaining on our clock, we will request that these be prioritized for our next sitting, so that we may be able to adopt the report and the minutes. I see the hand of Honorable Steyn is already up. Ms. Steyn. You are muted, Honorable
Sorry, Chair.
Steyn.
I had a solid, Chairperson, I had a solid proposal on the table that the department retracts this bill, but they bring it back to Parliament before 6 months. So it's before the end of November this year, so that we give them a time frame, Chair, to fix and bring a proper bill after proper consultation. Thank you, Chair. And I think it was seconded.
Thank you, Honorable Steyn. We have made notes of what the honorable members raised in terms of the session that we have had. And as the management committee, we will request from the Secretariat to write to the executive, as you can clearly see that the entire executive, even the minister who was with us on the road, is now offline. We will therefore be writing to the department to map a way forward in terms of what came out of the proceedings of today's meeting. So do enable us and give us the space to do that as the management team. Honorable members, with that said, we will therefore conclude this afternoon, this morning session, and I would like to take this opportunity to thank you all. Thank the honorable members who have availed themselves to attend, but also thank the honorable minister who was able to join us, particularly from the opening of the meeting, and as she was on the road, network was not allowing to have her on for the rest of the session. But we thank also the officials of the department as led by the DG, Dr. Ramasodi, with more emphasis on Ralph, who always helps us to navigate through these presentations, but we had some technical glitches today. We hope we can fix that in the future going forward. And we thank everyone else, our guests that were part of this meeting, for having been with us. Honorable members, have a wonderful afternoon and a great week ahead. Be reminded that there is plenary this afternoon starting at 2 o'clock. So please do connect at your earliest convenience. Thank you. The meeting stands adjourned.
Thank you, Chair.
Hi, everyone.
Thank you, Chair. And bye, colleagues.
Thank you, and bye.
Thank you, Ndumis.
Thank you, Mhlekazi Masipa.
Le ndade.
Didn't really guy.
Kwena ntuza ubulela sutunyana man, at least once a week.
Kwere la uruteana.
Ai mutuse ai didimetse kwana. Northwest.
Ubatla utusiwa mutusa, hasali mutuse yani.
Ai. No, ulukile ndade be
khotse.
Thank you. Bye.
Thank you.
Recording stopped.